It's the basis of the Amazon browser, the Samsung browser. Microsoft, of all people, just said we're going to move to the Chrome browser infrastructure because it's become essentially an industry standard and it's open source, so why not? So that's been, if you think back of all the browser battles 20 years ago, it's an interesting bit of history. Also, open data, because you've heard that how do machine learning systems learn? Well, they've got to have training data. And where's the training data come from? Mostly it's come from donations of universities, research centers, and companies that have utilized this data. So ImageNet, which is a big repository of labeled images, we donated 9.5 million labeled images. Now you had to pay people to label these images, okay? But once they're labeled, you can use them to train your system, and you can also use them with the rest of the machine learning community. YouTube, we donated 4.5 million labeled videos because computers are pretty good now at recognizing still images, but they're really pretty bad at recognizing actions. So you can look at a YouTube video. Are they exercising? Are they fighting? Are they marching? Are they dancing? What are they doing? And any of us could answer that question, most likely, but computers can't do it at this point. But now with the 4.5 million videos, we're hoping they will do better. Kaggle kernels, that's a machine learning system that we have that's got about 20,000 data sets. And we just introduced a month ago data set search, where if you describe your data, you provide some metadata for the data that you're providing, it's going to enable Google to find it much more easily. And that, of course, is an open standard, so anybody could use that as well. And finally, data access by individuals. We started a project 9 years ago called Takeout, Google Takeout, and it gave you the capability of downloading all the data that Google knew about you. And one of the interesting things about that is people use Takeout for different reasons, but there was no take-in. That is, if I downloaded all my Gmail and I say I want to switch to Hotmail, how can I do it? Well, there wasn't really an easy way to do it. And the same thing with maps or any other location history, anything like that. So now, a few months ago, we started this data transfer project with Facebook and Twitter, and you can actually move the data not only out of that service, but into an alternative service, okay? And, well, there's a lot of issues that still come up. Biggest one in my mind is the privacy versus portability. So when I download my Gmail, I might have mail from you in that Gmail repository because of the quoting capability. Or if I download my calendar, I have all the meetings that I had with someone else, et cetera, et cetera. So your data has this social component, and when you're downloading data about other people too. So how should that be dealt with? Another issue is security, namely if you are downloading your data, well, that puts you in a pretty powerful position. So somebody else might want to spoof you or do some phishing or do something else to try to acquire that data. So you need to be extra careful in enabling that transfer. But being extra careful, at the same time means there's going to be some little roadblocks in actually getting the final thing done. So people are saying, oh, you're making it hard to download your data. Well, you want it to be somewhat hard to download your data, because otherwise you could subject yourself to various risks. All right, and the final slide. There's a list of what you can download via Google Takeout. And the color just means there's a link to it in Wikipedia, because I copied the table out of Wikipedia. So any particular thing that you want to download from Google, it's there. And Facebook has a similar program, and now with the data transfer project, it's going to be easy to move it elsewhere. So we think this is a pretty good response to these calls for transparency, because we think that the right thing to do is put the decisions in the hand of the user. And now you have those choices to make in terms of downloading. And go to Wikipedia, you can see the same list and see what's involved everywhere. Okay, thank you.
Perfect. So Rick, you're one of the two.
Room. But I come from this from a litigation background and doing competition policy. So, to use Professor Kaminsky's taxonomy, I am deeply consequentialist in my approach. So I'm going to I'll start my talk from that perspective. So in the sort of telecom competition area where I tend to practice, when I think about transparency, maybe the same way you do, Michelle, is it's a tool to facilitate competition. It's a tool to prevent market failure, to enhance the ability of consumers to choose between various products. So if we think about transparency from that perspective, is there a way that competition might be sort of jump-started or transparency used to enhance competition on the privacy front? And if you think about food labels, I guess I can't remember when the FDA or USDA started doing food labels on food, but now you see lots of competition for calorie counts, organic products, and that's facilitated by transparency required by government intervention to make people reveal what their ingredients are, calorie count. Now you go to McDonald's and you see a Big Mac has 1,000 calories, you might make a different choice. Likewise, there's a lot of transparency in automobile safety. When I bought my first car, no one picked a car based on its safety considerations, but now car companies actively compete on a safety dimension. So one thing to think about is, can transparency be used to create or incent companies to adopt more consumer benefiting practices that will then, consumers will then be able to choose, well, I don't like what, say, Google is doing when I use Gmail, but so I will use a different email service, or I like Apple's privacy policies, so I'm going to switch to Apple Maps. I'm not trying to take a position on which one is right, but is transparency a way to do that? And it seems then one of the biggest problems we face is what is the information that consumers should get? Are we going to just overload them? We talked about obfuscation through transparency. One can imagine transparency notifications that would just swamp consumers. They have no ability to make heads or tails of it. Professor Claffey mentioned, I think, the idea of almost companies taking on kind of a role of helping consumers navigate, sort of being kind of privacy facilitators. You could almost imagine like learned intermediaries helping consumers pick companies based on their privacy policy, but we don't see that in the market, at least that I'm aware of. Maybe there are some, but so that raises the question: is can third parties step in to help consumers navigate among various companies' privacy policies and make decisions if they care about privacy among competitors based on their privacy practices? So, from a kind of, that's the way sort of I would think about these issues from sort of a telecom competition background. I'll be interested to hear the presenters who work for the companies about how they think about competition and privacy when they're looking at the marketplace. Now, the flip side of sort of regulation, privacy regulation, is it's well known that this type of regulation can often act as a barrier to entry. Large companies often can take regulation to their advantage, use it to block rivals, gain standards that get regulators to adopt standards that advantage them and disadvantage rivals. GDPR, some have claimed that GDPR has allowed Google to get an advantage in display advertising. I'm sure Professor Varian probably disputes that, but there still are concerns that maybe GDPR, while enhancing privacy, has reduced competition. And to the extent we're in a world of trade-offs, one would obviously have to weigh the benefits of enhanced privacy against possible costs in terms of reduced competition. I thought I'd turn a little bit, again, with my consequentialist background to the right to an explanation, which is an area I haven't dealt with before, but it seems very interesting. If you think about, I went to go to a bank and get a loan, and I went to, in the old-fashioned world, the loan officer would look at my application and would potentially say, sorry, Rick, you're not creditworthy, we're not giving you a loan, and I'd say, okay. And if I didn't like their, I could go to a competitor, and there was plenty of banks I could have gone to. It doesn't strike me as self-evident if a bank uses an algorithm to now deny my application, that a completely different regime should be in place, that I would now have a right to demand an explanation from the bank about why they denied my loan application, whereas if there was a human loan agent, there was no such right. It seems to me, just lurking in the background from that discussion, is there concerns about bias in the way the algorithms operate. And that's obviously a legitimate concern, and if these algorithms are operating in a way that has systematic bias against certain groups of people, that would be a problem. Ordinarily, one would think that most of these companies have strong incentives to get it right. They don't want to deny loans, in my example, to qualified individuals. And so if they have algorithms that produce poor results, they're going to be punished in the marketplace and lose business to their competitors. But obviously, you can't take that principle too far. There's plenty of instances where we'd expect businesses to behave responsibly and try to do the best they can, yet sometimes they do things that violate the civil rights laws. And that, just because you're trying to get it right, you have an incentive to get things right, doesn't excuse you from complying with the civil rights laws. So perhaps Professor Kaminski can talk a little bit about why generally applicable civil rights laws wouldn't be the better approach here. Is there something about algorithms that make it very difficult to do so? And then also, it wasn't clear to me that transparency is the right way of getting at that. You'd have a regime which was very episodic in when a consumer would get this information and know to request it, and even what to do with it. If I demanded my right for Citibank to tell me why their algorithm rejected my loan application, probably get something that said we have a 20-factor test that weighs these 20 factors, and we're not going to it's proprietary exactly how we weigh them. And I wouldn't be able to really pierce together it's because there's something having to do with my zip code that's the real dispositive reason. But one could envision a potentially more effective regime comprised more of requiring, say, data analytic officers, audit requirements, compliance with industry best practices that might be more effective than a consumer-facing right to an explanation, and possibly less costly as well. And I guess the last thing I would just mention, and I hope I'm not taking us off topic, is we haven't heard anything yet today about actual data protection, which seems to kind of follow directly from privacy. Obviously, a big concern is with companies that retain consumers' data for advertising or analytics or health research or whatever reason they're putting to it, it would be a corresponding obligation to protect the data, because in some sense, the worst thing from a consumer standpoint may not be how the companies use the data, but practices that allow, third-party state actors or criminals to get a hold of the data, and then hack you, assume your identity, and what's the best way of dealing with that? Often these companies are subject to effectively criminal acts. A lot of the hackers, after all, are committing a crime. Often they are state-sponsored or state intelligence agencies that are doing the hacking, and what standards should companies have to safeguard this information as kind of a quid pro quo for obtaining it and using it. It would seem that the current regime of 50 different state regimes without overall federal standards is not the right one, but what the right federal standards should be and how they should evolve. I'd be interested in hearing from our colleagues what their views are on what obligations they think their company should have to protect data, and what the best approach is to balance costs versus the obviously unfortunate consequences from data hacking for consumers.
You're getting very close to today's headlines, you know.
I haven't seen has there been another data hacking that happened today? So
If we say yes, they'll all move to their mobile phones.
they won't pay attention. Well, they probably stopped paying attention about 7 minutes ago anyways. So.
Thank you, Rick. Move on to David.
Great, thank you. Transparency is a very important topic, and much of the discussion has been about the consumer transparency aspect, and obviously that's important for a company like Verizon. We have a trusted relationship with our consumers, and so it's important that they understand what we're doing, how we're collecting their data, using their data, and what they can expect from us. There's that consumer-facing privacy disclosure piece of it, but there are other pieces as well. So if you look at the broadband internet practices, we disclose that as well, and make it clear how we will or won't treat broadband internet traffic, and those disclosures are voluntarily made, but of course they are enforceable by the FTC if our company violates any of those practices. But in addition to the consumer focused disclosure, there's also an important aspect of disclosure for broader societal purposes. And so an example that was mentioned earlier by Professor Kaminsky is the sort of government surveillance disclosures. And Verizon several years ago started producing a semi-annual transparency report that discloses the demands from law enforcement. So how many demands, what types of demands, warrants, subpoenas, orders in the US, and then as well as globally. And so this is not something that is necessarily something that consumers individually care about, or that is a competitive issue, but it helps to inform society more broadly about how these things are being used, and can help to guide policymaking in that area in a way that's difficult to do without that data. As we heard from Casey Claffey this morning, you need this type of data to make informed policies. So I think the policymaker education aspect is really important as governments start to set policies in these areas, with things like GDPR, and as the U.S. Congress, starts to think about creating a new privacy regime for the U.S., it's important that policymakers actually understand this stuff and how it works. And I don't know that there is as strong an understanding about some of these areas as is really necessary. Hal talked about the display and search advertising, which is really interesting and complex stuff, but there's a whole advertising ecosystem, with the supply side platforms and the demand side platforms and the real-time auctions and all of this, and how those things interact with one another, that is not as transparent, I think, as it probably needs to be, and it's certainly not as well understood by policymakers as it needs to be. I think there's another aspect of transparency too, though, and that's sort of the role that government can play in helping to create more transparency that can either be helpful in terms of promoting competition or dealing with problems. And we heard this morning about the FTC's power to conduct investigations and hold workshops and produce reports, and that's obviously a really important source of data and transparency to this process. I think some other examples that I can point to are the FCC's broadband speed testing. Before the FCC started to do this, there were a lot of claims made about broadband speeds that were perhaps based on different assumptions or different methodologies. And so, we were deploying a fiber broadband solution that we were very proud of and proud of the speeds that it was delivering. And we were concerned that some of our competitors were making claims, competitive claims that really weren't being backed up by the services that they were delivering. And the FCC started this broadband speed testing program where they worked with a company to put probes into volunteers' homes that would actually measure the broadband speeds, and then the FCC reported on that. And as a result, some companies changed their practices. It turned out that they weren't actually delivering the speeds that they had initially promised, and what we saw was that a year later they were delivering those speeds because there was this spotlight shined on it, and they in turn had to go and upgrade. So I think that's an example of how the government can use transparency to help make competition work better. And then finally, in that same area is broadband mapping. Where is broadband available or not available? The NTIA started the broadband mapping project. There's a lot of, and now the FCC has sort of picked that up. There's criticisms of the broadband maps, and rightly so. They could be better, but they're much better than the data we had before the government started to collect this information and publish this information. And so as we look to solving the digital divide problems and making sure that broadband is available everywhere, having that transparency into where service actually is available or not available is critically important. So I think I'll stop with that because I know we're going to get into some discussion. Thanks.
Absolutely. Thank you so much, David. And I'll just add in terms of rationale, since we've talked a lot about that and the different rationales in different contexts, that looking at the FCC's imposition of transparency obligations in different proceedings dating back to, say, 1996, the passage of the Telecom Act, you'll see a lot of it is definitely not philosophical. It's very grounded. And we came up with 9 different reasons that the FCC has imposed, often in different combinations. First is enabling informed consumer choice, enabling consumer oversight, enabling FCC oversight. Fourth is increasing competition on terms of service. Fifth is increasing interoperability and third-party access, and there's been a lot of situations where that actually has occurred, as we heard earlier. And then, promoting end-user confidence in networks. And seventh is supporting innovation. Eighth is uniformity of consumer experience. And 9 is lowering consumer costs. None of those probably surprising. What is interesting is virtually all of those appeared in the FCC's Open Internet Order in 2010, so they've relied on a stream of those over the years. What is interesting, though, is the manner of presentation. So how you capture whatever it is you're trying to convey to the end users or third parties. Does it make a difference how you present it? And what, has there been any findings or literature as to what the best approach might be, and does it matter? Should it be on a website? How do you avoid the too much information problem that Grace Coe referred to on an earlier panel, that it just gets overwhelming, or the obfuscation problem? So I'd like to hear from some of the panelists about the manner of presentation, how you do it, and what they've maybe learned or seen over the years. How? Yeah.
I'll say something about this, this right-to explanation. Those weren't the words you used, but
Yes.
same words.
Same.
Okay. So suppose that you show me a picture and I say, oh, that's a picture. Hello?
Actually, you don't have one. Do you? No, okay.
I've got it, but it doesn't want to be used. All right, I'll speak loudly. You show me a picture, and I say, that's a picture of my wife. And then you say, well, how do you know? And I say, well, I've seen a lot of pictures of my wife, and the picture you gave me looks a lot like them. Now, a machine can say that too, because that's how they're trained. They see a lot of people who default on mortgages, and your application looks a lot like them.
Yeah, I know.
That's a generic explanation for everything, but I don't think
So, you know, I think there are different needs by different people. So consumers, you know, to the extent they care, you know, need something that's in language that they can understand and you know, find meaningful. But I think, you know, it's not just the consumers that need to understand the company's practices, but also experts, privacy experts, you know, who can read the more detailed legal documents and interpret them and opine on them and provide guidance or, you know, reaction, you know, either positive or negative. And then I think there's a third category, and that's I think that we should be thinking about or looking at how we can make some of these things machine readable so that, you know, I don't need to click on a legal document and read that before I click yes. You know, if there were some trusted intermediaries who could, you know what my preferences are and then read a company's practices or policies in a machine-readable form and then take action based on what that trusted intermediary knows I would prefer. So I think there's a piece that doesn't really exist today, and I'm not sure exactly how you get there because it's going to require some kind of standardization or, you know, at least agreements for interoperability purposes.
Just jump in a little bit. I mean, I agree with David. It doesn't seem to me you have to have a one-size-fits-all regime. I mean, you know, going back to the food labels, those are fairly simple, and consumers do seem to be able to understand them and make choices. Privacy regulation does seem to be a little more complicated, but one could envision a regime which is simplified disclosures that are more consumer-facing, and then more complicated disclosures that are more expert-facing. Of course, whether there's going to be communication from the experts to consumers who are ultimately would be making the decisions that would then give incentives to drive behavior by the companies is really the big question. David talked about the need for government standards, and that seems to be would be a role for the government. You can't, if no one can agree on what a speed test is, then there's no way for consumers to compare speeds of various internet access services because everyone's got some legitimate claim for how they measure their speed, which preferences their speed and, you know, makes them look as fast as Verizon's fast, which I say is quite speedy. I'm quite pleased with it. So, but you know, so you do have to have. It would seem you need to have standards to ensure there are ways to make comparisons between companies, and there would be a role for government to do that.
Actually, to respond to a point that Rick just made, one could make a regime where there are simplified disclosures directed to individuals and more complex, deeper disclosures that are directed towards regulators. And that regime, I hate to say it, would be called the GDPR. So let's go back to that again. Yes, I think there's a pretty widely accepted understanding that individuals making decisions, even as consumers, consumers in a marketplace need a very different kind of information conveyed in a very different kind of way than expert oversight bodies, be they regulators or technologists, need when they're assessing something, especially when it's first being built. And so this is why, just picking one type of transparency isn't going to solve everything. There's no way one type of transparency could possibly solve all of those different kinds of problems. And one example I wanted to give of this, there's a very famous, I hate to say it, law review article that's about restaurant grading. So we keep talking about food grading and disclosure. And it turns out that, so restaurant grades are those, letter grades that some cities have. They put up that say like A+, go here and eat, or D, don't ever set foot in where your child will die. And it turns out that that was put in place largely as sort of a nudge-like regulation supposed to incentivize restaurants to compete with each other, a la the broadband example that you gave. And it turns out that in different cities, this played out really differently. So in San Diego, for example, it just caused a lot of grade inflation. So there was sort of too much cooperation between the regulators and the restaurants, who just said, like, yeah, everybody gets an A. And that didn't change food safety standards. And then in New York, it actually, probably very New York-like, instead of producing cooperation, produced more antagonism and diverted enforcement resources from actually searching for food safety problems to resolving disputes over restaurant grades. So all this is by way of saying, we understand that we need to have different kinds of information communicated in different ways towards different bodies, and that there has to be some sort of bi or multimodal type of use of transparency to accomplish different ends. I think that the truly difficult questions end up being sort of how the layers of the systems are supposed to optimally interact with each other. And then, of course, what we haven't talked about in our panel of transparency is where the appropriate blocks to transparency take place. Like where do you put in the exceptions, both to the regulatory oversight and to the individual forms of transparency that you're trying to communicate.
So let me throw in one more observation that hasn't been made yet. I claim that Google's the best thing that ever happened to privacy. Why would I say that? Why? Because people ask questions of Google they would never ask a person. How do I know if I'm pregnant? What are the symptoms of herpes? What happens if I don't declare $10,000 worth of income? Blah, 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 blah. We know they ask. Because you can see it in Google Trends. Completely anonymous. Yeah, exactly. Exactly. And you think about that's unique in human history, right? We're finding a completely disinterested source that you can ask these questions to and get good answers, get good authoritative answers, which is generally going to be very helpful to you. So the fact that people are willing to ask these questions to the machine is, I think, noteworthy in itself. Right? We know the old line, two can keep a secret if one of them's dead. So Google's not exactly dead, but we don't really want to say it's alive either. So in that case, I think that you've got this great service. Now, it's exactly why people are worried about data being disclosed, because they have asked such sensitive issues, and they want to be sure that they have this secure. But realistically speaking, it's a heck of a lot more secure than your doctor's record keeping or your lawyer's record keeping or almost any other small firm's record keeping, because so much effort is devoted to making that as secure as possible.
But is it enough that the consumers know that that is going on and that their data may be used as a currency on the platform?
So what happens is that when I showed you, talked about interest advertising, nothing sensitive goes to advertising. Some people could argue it should. There might be, let's say, delicate health conditions or something that benefits from that. But the policy is. So it's just when you ask these questions, they are just basically the goal is to try to give you the best answer to the questions that you ask.
Margot, any reaction to that?
For the rest of the question.
Okay. One question is to dig a little deeper on this notion of a data fiduciary and what that might be and what it could look like if we need some type of fiduciary in this area. Any thoughts about that? I think it was David, you brought that up.
Well, no, it's something that is now, part of the, discussion in Washington DC. People are looking at the fiduciary responsibilities of more traditional fiduciaries and saying, is this something that could be applicable in the privacy, data collection, data use space? I think it's certainly an interesting concept, and the idea that, a company that's collecting and using data about its customers should not use that data in ways that may be harmful to the customers. I guess the question is just exactly how would it be applied in the privacy context, and how would sort of the common law that's involved in the other contexts apply or not apply in the data use context, and even so there are just a lot of unanswered questions there. I think
it would depend on what the customers think that their privacy rights are in a sense. Obviously, if you take the information and sell it to the Russian mob, I think the data fiduciary would be able to say you can't do that. But I don't know, does the fiduciary then say, no, you can't, they gave you this data, but you can't sell it to a data broker, or you can't use it to market certain advertising, to market certain products based on these characteristics of the user that he or she might think are particularly sensitive or not. So it does seem an interesting concept, but one would be fraught to apply.
Well, suppose you submitted your mortgage, your application to the bank, and a half hour later they come back and say, Mr. Becker, you really can't afford this house. That would be really good. That would be really good. In fact, because of your financial situation, that you should do this analysis says that you should probably, well, if more people got that information in 2000, probably would have seen the great, in 2008, we said 2008, we said great crash.
We talked about the GDPR and the role that Europe has had in driving companies in a certain direction with respect to transparency. What about China and other countries that may be driving it another direction? Now that we have a global economy, I think Rohit talked this morning about some of the issues and concerns there. Any reactions to how that might impact us going forward?
So I think it's really important, as we develop and implement policy in a space that we think about the global marketplace and the fact that these platforms operate on a global scale. And so, one of the things I think made the U.S. very successful in this space and allowed companies like Google and Facebook and all the rest to emerge is the fact that we had common, consistent U.S. policy framework, that was very deliberately put in place back in the late 90s, to encourage this kind of digital commerce. I think the Europeans have had a more fragmented approach in many regards, and I think GDPR is an attempt to create more of a consistent framework to help them compete better in this space. And then, of course, China is its own special case. So I think as we look at policy making in this area, we should not throw out the baby with the bathwater here, and I'm concerned about some attempts to impose state-level internet policy regimes, whether it's in the privacy context or net neutrality context, because it's going to lead to a fragmented market in the U.S. that's going to be harmful to innovation and raise costs throughout the ecosystem.
I think Professor Kaminsky's talk was aimed a lot more at right to explanation, right to private action for Private Actors Act. It would seem pretty self-evident that when we talk about state actors using algorithms to make legal decisions with legal effect raises a much broader set, more significant set of concerns. There's ability for market forces to constrain a state are obviously much less, and the consequences of decisions made by a state much more significant. Ordinarily, the federal system typically have agencies do have to explain their actions when their actions with legal effect. You do have a right to be heard and have an explanation for the action, and that's that would seem to raise significant concerns. Again, obviously, when you start talking about China, you get into concerns that the government keeping a social utility score on everyone and using that as a basis to determine what benefits and jobs you get. At least my idea of a nightmare scenario. Hopefully, we're nowhere near that. But
Hal, you were going to...
Yes, I believe that the next 30 years, the global hot button issue is going to be health. Why? Because the developed world is Europe. You look at Italy, Germany, Switzerland, Spain. They all are bad from Japan. Just about to get to Asia, which is already there, essentially. But interesting enough, China has a one-child policy has been a demographic disaster, haunting China for the next many years. It takes 20 years to raise it. You can Google, can't you? But the point is, it's a demographic in spades. And then the question is, privacy research, for doing medical and health-related issues, which is a hot button Everybody is in favor of better, more expensive, reliable, health care. Well, Europe has GDPR, we have HIPAA, China has nothing. In this area. So wouldn't you expect a lot of technological advance in China? Some of which I'm sure will be exported or will be utilized as well. It's I think you fast forward and start asking, well, why is China so rapidly and we're moving slowly by comparison.
Yeah, so I realized I missed the boat. On being able to answer your fiduciary question. My time. I do want to talk about the international landscape. I think there's something. And I think the China sort of social order is a little bit of distraction. That conversation that's still worth accountability conversation. So on the international, it's been so fascinating. And we're all aware. New privacy law scholar. So my longitudinal perspective is relatively shorter. But even in the time that I've the conversation is really shifting from the U.S. isolation, no regulation is the way to go. That's the way to go. Apologies to the FTC. And to a conversation that is now the unilaterally setting standard. And the U.S. state by state California being with prime example, but Washington follow, responding to that upward ratcheting. And so the international dynamic picture for a second does appear to be one of upward ratcheting. And the question is going to be what style wins. Are you going to have a Brussels effect where the EU unilaterally regulates its arms really long, and that causes everybody to go up to the EU level, which causes everybody else to come up also. Or is it going to be a California effect where you have emission standards and a state that has an outsized impact, causing regulated companies to actually lobby on its behalf, and so the poor federal level companies in California saying this is costing me a lot, so I might as well go to Vermont and lobby for similar legislation. Vermont has to do some regulatory costs. China complicates that, right? Because you have been a parallel system to this kind of regulatory dynamic that seems like it's outside of that box. And I am not an expert on Chinese data security, but I was on a panel recently with somebody who is, and what's interesting is that that's not a non-existent conversation. There is actually some upward ratcheting of regulation there too around that. Now, going to the social media, I think it's terrible that China does this in privacy as a privacy risk, because the thing you sit down and possibly go terribly wrong. What's also interesting to me, and this describe it, and this goes back to a much earlier answer, is that score, that I think Americans most understand as being credit score, and a lot of the conversations started by letter or worse as a model, the Fair Credit Reporting Act of saying, we have to score, it follows us everywhere on our shoulders, in all major decisions, shouldn't we be able to in some way contest that, or get some insight into what it is and why it's there, and so the Chinese utility social utility scenario kind of gets back into that conversation. You look at all right, I'll have a score on from FICRA and from FICRA, and places like Google, right? And so going back to a question I did not answer earlier on, that I think is really important to talk about. I believe it was Rick who asked, why not just use straight up anti-discrimination regulation? And I think there are two discussions around that. One is our actual details of anti-discrimination laws don't work really well. You have algorithmic decision-making because the exceptions to the laws is a matter of doctrine, is to show that your decision is based on statistics, and that's in fact how decisions make decisions. And so you get the loophole in the anti-discrimination law. So that's a highly legal technocratic. Why not anti-discrimination law the way it's currently written? The less detailed answers, at least as I understand it, with a lot of these systems, you actually do want maybe not direct regulation, but you want the oversight early on enough system building of the system. If you just have an ex form of liability, then you don't necessarily get the audits put in and the other forms, oversight, regulatory oversight put in at the point where you're constructing the system. So that was a very long answer to multiple questions. I still do talk about data fiduciaries as well.
Actually, it's already questions, including one from a student. Here comes the mic. Excellent, thank you.
Hi, Vince DiMichele, not so much this kind of relates to the obfuscation, so much information, but yet all concerned that transparency regime would function a lot like discovery. You know, I use 95%, that I'm holding is the real critical stuff, the red flags. All worried about that.
Good question.
In short, that appears to be helpful. With respect to government transparency, yes.
Well, I think this goes back to the concept of providing some assistance right now. Right now, consumers can't read all of the privacy policies that they're abiding by or subject to realistically, and so it is overwhelming. And that's where I think the expert role and player role and where opportunity exists for intermediaries that operate on their behalf. And on this subject, I want to give a hat tip to Richard Witt, who's doing some really interesting work in this area on how to address these problems.
Another question?
I'll provide it. The example on lunch was European who boundary data, location data. You got the data. He says, I can't read this. This is all garbage for Well, of course, release the data in machine-readable form to hundreds of applications the web just drop in, and it will file in, and it will produce a human-readable form. So there's a case. So then he filed it. Not only do you have to data, you have to provide a human-readable form because I don't want to bother to go use these applications to do the transformation. Of course, I think any sensible machine readable is way to go because then you can produce it in any format you want. All right.
Question, yes. Question, yes.
Hey there, guys. I'm Danielle Citron from the University of Maryland. Your comment you asked, has there ever been a time when we're going to ask such sensitive information, and that there's this gloriousness of privacy? We did have it, or we still do in librarians, right? We go to libraries. We entrust in them our most intimate intellectual engagement that we think of. If we think of privacy values, and the apex of those privacy values and interests should be. You go to a library, you look up purpose, and you go to a library and you engage in ideas that are dissenting and different. But librarians have a deep-seated obligation as a professional matter, privacy as well as privacy as free expression. And so that then I think leads us to the question of the fiduciary model. That there may be when we think of certain kinds of data that are particularly sensitive to important to our consequential and deontological lives, that they deserve fiduciary commitment, much in the way we think of intellectual privacy and sexual privacy. I'm going to add on sexual privacy, right? And there are others, right? That I'm not entirely convinced that Google's so great for privacy when those searches are shared. We use them in advertising. They get embedded in scoring. So I just thought it may be worth circling back to that. Margot, talk about the fiduciary model, and maybe you can jump off of that to talk about it in other respects too.
They are shared, and they are used for advertising because nobody considered as a sensitive category like tax information or something. But I do agree with you. Our librarians are the closest we've come to a reliable source for providing a pretty secure basis. But doctors, many other professions also practices that are supposed to ensure safety. Sometimes they work, and sometimes they don't.
Although I think the client comes from a law firm and gets this personal sensitive information. We don't then sell that data to a third-party data broker. Usually.
Watch the news stories. I guess the question is where Google draw bound on what is personally sensitive and then off limits to further dissemination, and how does it make that? Remember, there isn't any dissemination. What happens is the advertisers say, I want to show this ad, and people search for frying pan. That's it. The advertiser doesn't get any information about that. It is by its nature a system pretty good in terms of the privacy. And policy makes it better because if you did anything like we described, you would be fired within minutes.
But the library example is interesting because if I go to the library and I do a search on flu symptoms, the librarian keeps that to herself, and that's all good. That's all good. If I go to Google and search that, you don't use that for advertising necessarily, but you can use that to actually identify, the spread of the flu or other, right? And so aggregated, anonymized data is actually very valuable from a societal perspective.
And Margot may need to wrap up because we're already just about out of time.
So I'm going to wrap up by talking about it. There are things that I love, because I feel like this is like a conversation we haven't had yet that I want to have with you in particular. we'll have it in a public forum. So welcome everybody else. So I think on the one hand, there are things I love about the data fiduciary model. One thing I truly love about it, with the librarian example, I think hit the nail on the head, is this idea that it recognizes, as do a lot of really old U.S. privacy cases as well, that if you don't have a communications environment that you trust, you may change your behavior in ways that are really harmful to broader societal interests, anything from sexual identity to your identity as a citizen in a democracy. And so the emphasis on trust and its importance for a communications environment on which our democracy is built, I think is incredibly valuable. And coming to the theme of this panel, using the fiduciary model to say this trust is about a relationship that you have with an entity that has obligations towards you, including obligations to communicate to you when it is not acting in your interest. That also has some real value. So again, we're all the things that I like about it. Where I think the real weakness lies with solely a fiduciary, info fiduciary model is that you miss the data brokers, right? You get the hook into the data brokers by asking the fiduciaries, such as the Facebook of the world, to not communicate the information to the third party. But again, having spent a bunch of time with GDPR's direct requirements on third parties, you don't get any hook into those third parties at all. So in some ways, it's really consistent with the American model of information regulation, where we go after the direct consumer protection relationship and don't look to the data protection relationship writ large. And if you disagree with that, I would love to hear more from you about that in the subsequent.
And with that, thank you so much to the panelists. Really interesting.
Alrighty, so if everyone could take a seat and we'll get going. All right, welcome back, everybody. I hope everyone enjoyed the break and is ready to move on to our next panel, which is Evolving Notions of Platform Responsibility, moderated by Rebecca Arbogast. Rebecca is currently Senior Vice President of Global Public Policy for Comcast Corporation. Prior to joining Comcast in 2011, Rebecca served as Managing Director at Stifel Financial. Before that, she served as the Chief of the International Bureau Telecommunications Division at the FCC. Rebecca?
Thank you. So I have a little bit of a cold open to start with. Don't get your hopes up. It's not a replay of Jeff Bezos' selfies from last night. Last year, as I was getting ready to be on a panel here, I stumbled across a survey I'd not heard of before. It's called the Edelman Trust Barometer. They put it out. They survey people in about 25 to 30 countries, and they've done this for, I think, about 15 years or so, and for some reason, they always seem to roll it out at Davos. And so I just looked to see what they'd done this year, and I thought I would bring it and share it with you guys. So in 2017, so this is looking at the change from 17 to 18. In 2017, the headline that they reported was a global crisis in trust across institutions, across the board. And keep in mind, this was right after our presidential election. It was right on the heels of Brexit. At that point, only about 15 of respondents said the overall system was working for them. That crisis, what Edelman called a crisis in trust, continued in 2018 with the U.S., if you can see that, with the U.S. seeing the largest ever recorded drop in the survey's history. So in 2000, I can't switch it with my finger, can I? So in 2019, which was released last month, again, at Davos, they reported what they called, quote, a profound change, with people shifting the trust to the relationships within their control and the trust becoming more localized. So Edelman describes this as originally the trust was conveyed top down, then it moved peer to peer across social platforms. Now they claim that the people trust what's close to them as the trust in other institutions has plummeted. So what you see here, somewhat surprisingly, I think, is that 75% of respondents trust their employer, but equal 57-56 trust NGOs and business. This was similar to last year when I got to point out that Gene Kimmel was on my panel, that people trusted he and I similarly. And then 47% trust the media. In this particular question, we went back and looked. Media was defined quite broadly. It included both mainstream traditional media as well as social platforms. What was interesting, I just picked a few slides that I thought were interesting. Another one that was interesting was they report in this past year a massive rise in engagement with the news and mainstream media. So what they concluded was that people actually want to be informed. What they saw was a 22% jump in engagement with mainstream media. But still only about 20% feel that the system is working for them, which is a pointed, continued concern. The other thing they found that's more getting relevant to our panel is that trust in social media remained low at 43%, and 73% of respondents are worried about fake news. And then finally, and make of this what you will, another slide that they had in there was that men are more trusting than women. So our panel today is entitled Evolving Notions of Platform Responsibility, and I think any discussion of platform responsibility and how that's changed over time need to be grounded in the evolving role of platforms and what they have in our society and in our lives. So the statutory regime that we haven't talked about a whole lot today so far, but those set of frameworks that were set up, government orientation posture towards the internet back then, as well as 230, which was a real cornerstone, was 20 years ago. And 20 years ago, Google didn't exist. Sergey and Larry had only just met. Mark Zuckerberg was in 8th grade. Amazon was 2 years old and was only selling books and only in the US. So what a difference a day makes. Fast forward 20 years, and all of those are deeply embedded in our lives. As I was driving home from work maybe a couple weeks ago, I heard a story. Did anybody hear this? It was a reporter named Kashmir Hill who reports for Gizmodo. And they covered her. I didn't hear the whole thing, so I went back and looked it up. She wrote, and you can go back and look at her stuff. I actually recommend it. She wrote, Amazon, Facebook, Google, Microsoft, and Apple collectively make products that we love, products that we hate but can't stop using. Their devices and services make our lives easier than they've ever been before, yet more complicated in unforeseen ways. Maybe you're in the camp of people who worry that these companies have too much access to our purchases, our movements, our social networks, and perhaps even our thoughts. Maybe you're disturbed by the concentration of so much economic power in a handful of companies. Or maybe you want them to have less insight into your life so they have less sway over our society. But how? Is it even possible? The common retort to these concerns is that you should just stop using their services. So I decided to try. So she goes on week by week, she cuts out one company from her life, and she doesn't just quit using, like putting posts on Facebook. She hired a technologist who put in a VPN into her system so that everything that interacts with Facebook is shut down for a week, and she moves on through this. The headline, she's in week 6 now where she's gonna cut them all out. I think it's just gonna like explode on her. But the headlines, and she does a very thoughtful reporting of what this meant and how this worked that I actually commend to people. But her headlines were, week 1, I tried to block Amazon from my life. It was impossible. Week 2, I cut Facebook out of my life. Surprisingly, I missed it. Week 3, I cut Google out of my life. It screwed up everything. Week 4, I cut Microsoft out of my life, or so I thought. Week 5, I cut Apple out of my life. It was devastating. So given how much has changed since the early days of the internet, say 20 years ago, how do we parse out the many issues that come up? Casey had her list this morning, which I think probably would mirror a lot of ours. Privacy, misinformation, disinformation, hate speech and the immediate violence that it seems to be triggering around the globe, algorithmic discrimination that Commissioner Schoper talked about, market dominance has been discussed. What hasn't been discussed is an interesting case from a German agency last year that looked at the combination of dominance and data privacy, which I thought was interesting. So what's the best policy response? Senator Mark Warner put out a paper last summer, a white paper that's the most comprehensive, most detailed, I think, consideration of that I've seen out there in the US space. In the UK, and I don't know how many people are following this, the government is expected to issue a white paper in the next few weeks. They've got a lot on their mind right now. And so it gets pushed back, but it's going to be on platform responsibility, and what they're talking about is imposing a duty of care, calling out specific harms. So they're going to go through, if it comes out in the next few weeks, they're going to do a public consultation over the summer, and then probably early the next year put out a legislative proposal. They're considering whether to rely on self-regulation or expanding the remit or the jurisdiction of Ofcom to include platforms, or whether to create a new agency altogether. So at Davos, again, Davos, leaders from Japan, South Africa, China, and Germany issued a call for global oversight of the tech sector, which is all easier said than done, but clearly the questions aren't going to go away. So we have wonderful panelists and respondents. We're covering a whole range of different issues that pick up different threads of this. As I said to somebody last night, I feel like more just sort of curating conversation at a dinner party, so we'll look at it that way. We're going to start with Professor Citron, who's a professor of law at the University of Maryland, and as my colleague Rudy Brioche, when he introduced me to her, said she's a rock star. Leading scholar on privacy, free expression, civil rights, including sexual privacy, and the relationship between 230 and free speech.
All right, so
I can just turn this off.
thank you so much, Rebecca. It's really fun to be back at the Flatirons. I feel like I have so many dear friends on the faculty and alumni of the faculty. I feel like I know this room. And just a quick note about Cash Hill. She has a book where she describes living on Bitcoin. This was about 4 years ago, before Really, anybody took Bitcoin and she like lost 30 pounds. And she always has such an interesting take on new technologies and their intersection with privacy and free speech. Okay, so now on to Section 230. I don't know if anyone's heard of the site called Omegle. It is an anonymous chat service. And on the banner of the site, it says, meet strangers with your interests. And on the banner, it goes on to explain that it's an anonymous chat service. It's going to connect you with strangers who will soon become your friends. And the last line of the banner says, but be careful. Predators are known to use our site. And lovely. And Omegle, how it used to at least look, I think still does today, it seems very kid-friendly. It's like in bubblegum green, Omegle with bubble letters. And at the bottom, there's a footnote that says, everything that happens to you on this site is on you. We're not responsible. And you might, in horror, say, how can that be so? And they're absolutely right. So when predators meet young children on the site, and as might happen, children are raped and kidnapped and murdered, they're right that they're not responsible, even though it's pretty clear from their tagline that they recognize that they are in the business of facilitating connections between children and predators, right? Now, so you might say, we've alluded to, and I sadly missed the first 45 minutes. I was flying in this morning. So I don't know if we've described Section 230 of the Decency Act.
Not in any
Okay.
way.
So yes, 20 years ago, there was something called and I want to be clear, I'm slowing down for a reason, the Communications Decency Act of 1996, right? And what the whole idea behind it was to essentially rid the internet of porn, which now you may think, like, seriously? Isn't that the only thing that's on there? And the concept was, and it was a way overbroad statute. Most of it is struck down in one of my favorite Supreme Court opinions. But what's left standing is Section 230, which says the title is Good Samaritan Protection for Blocking and Filtering of Offensive Content. And what then follows, and we had pretty conservative, both on the Senate side and House side, folks, so Chris Cock on the House side and Ron Wyden together write this version that becomes Section 230 of the Decency Act. And the idea was to encourage online service providers to self-monitor, right? Knowing that they couldn't catch everything. They might under-filter, they might over-filter, but the idea was to nudge them to filter and block offensive material. It's in the title of the statute, right? This is an anti-porn provision statute with an immunity, a safe harbor, for online service providers that engage in good Samaritan behavior. But the way it's drafted, if you over-filter and you do it in good faith, you enjoy the immunity from liability. But the provision that talks about under-filtering, you read it, and it can be read quite broadly, and courts have. It says, no provider or user of an interactive computer service shall be treated as the speaker or publisher of information provided by another information content provider. It's like a mouthful, I know. But essentially, it's saying, just read alone, without looking at the title, without thinking of the purpose of the statute, it's basically saying that service providers are they're immune from liability for user-generated content. And it's been expansively interpreted to cover what Ben Wittes and I call the bad Samaritan. So revenge porn operators, right? They brag, and I think they're not right to brag, but they're correct in their assertions, that they can explicitly encourage exes to post nude photos of their, more often girlfriends, to humiliate, embarrass, and shame them, and include their home, the people featured in the photos, their home addresses. And the website operator, the revenge porn operator, bears no responsibility, and courts have so held. Website, often on college campuses, so you have scantily, pictures that are embarrassing of people, including their details, embarrassing information about them. And Nick Ritchie has he's made a business out of embarrassing people, right? Omegle is immune from responsibility, right? There are subreddits devoted to upskirt photos and down blouse photos. And even if the Reddit knows full aware what's going on and doesn't remove anything, they're completely immune from liability, right? So it seems antithetical to the point of Section 230 is to encourage self-monitoring, right? Because at the time they knew, and they knew well, they would be outpaced, that law enforcers would be outpaced. They couldn't possibly keep track of all that porn on the internet, right? They wanted to see service providers regulate themselves, right? And so what we have seen is an overbroad understanding of the statute that has encompassed the bad Samaritan, the bad malicious actor, and so has stretched the immunity too far. It's unconditional. It does not require, as it's been interpreted, it has lost sight of its original purpose for Good Samaritans. And even Ron Wyden and Chris Cox both have said on reflection 20 years later that they regret it's been interpreted in overbroad ways and gone so unmoored from the notion of the Good Samaritan, right? And what we often forget in conversations about Section 230, and it has been really important, so I'm not here to say it's a bad thing, right? We have Yelp and Facebook and Google and Twitter, and I have to say I like some of those, right? I don't know where Hal is, but I can't live with Google. Can't live without it either. At the same time, right, those are incredibly important. But it also, in interpreting Section 230 as we have, it means that sites that are in the business of illegality get to walk away scot-free, right? And it also, as we think about the free speech calculus, so I write a lot about online harassment, non-consensual pornography, and more broadly invasions of sexual privacy. What we know is that when you're under assault online, you retreat, you go offline. And my co-author, John Penny, and I have done some work, and he's done an empirical study showing that the even presence of anti-harassment laws actually reverses the silencing effect. If you feel that you have somebody to go to, right, that when you're under assault, you might stay online rather than retreat. And we often, as we think about Section 230, we overestimate the cost to the harassers and underestimate the expressive costs to victims of online assaults. So I don't know how much time I have left.
Good.
Am
Go.
I okay?
No, you're
so
good.
Ben Wittes and I have proposed a modest change to Section 230 to sort of bring it back to its original purpose of the Good Samaritan and say it's a conditional immunity, but only you enjoy that immunity if you engage in reasonable practices to prevent or address clear unlawful uses of the platform. So I felt like we were being sort of moderate in our approach. Another one is so Jeff Stone and I have had wonderful conversations about other ways to narrow Section 230, which is to say you don't enjoy the immunity if you knowingly encourage and facilitate illegality that causes clear cognizable harm. So we certainly could work on this. And I know in our discussion, we're going to talk about FOSTA and SESTA, which I don't know if it's the sex trafficking sort of carve out to Section 230, which as much as I have to say, I worked really hard with Senator Harris's office, just, sometimes they don't take your advice. It's overbroad and it's like a disaster. It causes the moderator's dilemma, and we've seen like over and under reaction to it. So there are better ways to do reforms for Section 230, and I hope that we'll start considering some better ones.
Thank you very much. I think for a lot, there's a discussion going on in a lot of circles right now about what to do about Section 230. Should it stay, with essentially no updates at all, the risks associated with digging into it, and what does that mean? So thanks for teeing us off with that. So our next speaker is Professor Bombar, who is a professor of law at the University of Arizona. Her research is empirical research, and she assesses the social costs and benefits of big data. And she's done some empirical research that goes into questioning the wisdom of some of the many laws that are proposed for reform. So thank you.
Great, thanks. Well, I decided to challenge myself with this opportunity to be here with you today, this distinguished audience and panelists, to try to figure out how I feel about the last couple of years of the debates about Facebook and the election. And basically, what I think we're all trying to figure out, and have been for the last 2 or 3 years, is how we all became dumb and mean. And so the first, I think after the shock of the election, I think the first sort of attempt at explaining what happened was that what was latching onto the fake news conspiracies from Macedonia and Russia. And pretty quickly, I think, we realized that doesn't seem to be much of an explanation, that the circulation was actually pretty modest of fake news, of factually, verifiably fake news. And the influence of it, too, was also probably quite modest. And the next iteration, which I think we're working with now, is that Facebook is still at fault here, but what they have done, this is the sort of Cambridge Analytica story, they have facilitated the spread of propaganda and manipulation through by allowing hyper-targeting of content. And so that's the model that most of us are working on, and I think that there's some truth to that. However, I think that too does not actually leave much of the story fully explained, and unfortunately I've come to the conclusion that the biggest problem we have is totally popular, authentically believed, possibly even well-intentioned misinformation. And so then if we reverse engineer what types of solutions we'd want, they don't look very consistent with the First Amendment. They also just don't look like very good policy. So that's where I'm headed. But before I get there, let me do some disclaimers. So much of what I have to say today is empirical assumptions that we don't have a very good way of testing, or even if we did in theory, we just haven't yet. And so my arguments here are, they're sort of, my convictions are strong, but I hold them very weakly. I don't hold them. And I was telling Rebecca, I actually feel very nervous about this talk because I just don't know how I feel still. And so if you have, please during Q&A or after, this is the perfect, moment for an academic where I'm really receptive to more research that I'm not familiar with, and my mind is able to be changed. But this does come from some of my past work, and then also, it also gives me a chance to reflect on a book that recently came out by Yochai Benkler and his colleagues called Network Propaganda, which I think is fantastic, and I think it's very valuable, although I'll disagree with it to some extent. Okay, so the idea, the basic model that I'm working with is that Facebook has failed to do something. We don't need to say specifically what right now, but it led to manipulation, and I'll talk about that later, but I'm also not going to define that right now. And then that led to some kind of change in people's attitude or political engagement or something that we find troubling. And Benkler's book mostly agrees with the second and third part, that politics have gotten more divisive, and beliefs have gotten wackier. However, they find, using their own giant database of communications, that this was actually a pretty slow-moving process. And also, perhaps most awkwardly, is that the information ecosystem has evolved such that ideologically right-wing media organizations are now kind of off in their own insular world, where most of the links are to each other, but not to center or center-left media organizations, whereas the left side of the ideological wing doesn't really have this problem. And that's quite awkward, because it means we have to do dirty work of actually talking about ideology, right? It's easier, it's much more comfortable, I think, to blame Russia or outsiders or technology like Facebook than it is to say, okay, conservatives, shame on you. So the book also concludes, and I'm probably not doing a perfect job paraphrasing this, so please read it yourself, but they also conclude that this was very slow moving, that actually this started in the 80s with talk radio. To pick up on some of what Patty said earlier, that this may, my impression too is that this may actually be a reversion to the mostly natural state of human behavior, and that there may have been something going on, a couple decades ago that was actually the unusual part. But the book is largely studies that have come before. of Facebook's not just responsibility, but even influence have been a bit exaggerated, have been misunderstood and largely exaggerated by both Congress and the popular press. And what that's really saying is that I think there's some reason to question the causal story. So because I teach torts, I'm going to break this into factual causation and legal causation. Apologies to those of you who are now having nightmares of remembering your torts class. But for factual causation, we're supposed to ask but for. So but for Facebook allowing hyper-targeting, would we not have much of the political divisive behavior that we see today? So that's the question that needs to be answered yes in order to say, okay, then there is a factual cause here. Another way of putting it, and this question is not just related to Facebook and recent politics, but really to speech and of every sort, is to what extent does speech merely reflect what people already believe as opposed to influencing what the listeners are going to think. And of course both happen, but content, whether it's on Facebook or anywhere else, is simultaneously reflecting and influencing. But what's the breakdown? Well, I thought I would, because there's not great way to measure the effects of political speech, I thought I'd briefly talk about advertising, because there's a private incentive to try to measure these things, and so we know a little bit more about it. So if you imagine, let's say a group of people were shown a behaviorally targeted ad on Facebook. Some portion of them wind up ultimately buying the product from the manufacturer or service provider that targeted the ad to them. Well, some portion of them, the part I marked in green, would have bought that exact same product from that exact same producer anyways. And so now that portion of the pie chart, much of this I'm just kind of making up, but the green portion I'm not. The green portion actually comes from a really cool study that Facebook just allowed some researchers at Northwestern to do, where they actually did a controlled experiment. And so they knew who would have been served based on hyper-targeting some ads, and then they just didn't serve it for some of them. And they looked at, and then they also had, because they were working with the retailers, they also had actual purchasing behavior down the line. So really unusual that we have this precise, and on average, it was a little different for every product, of course, but on average, about 60% of them would have purchased the exact same product and service. Anyway, okay, so then the rest of the pie, I'm kind of guessing, but some portion, which I put in blue, I know you can't read those small text, but the portion in blue is meant to represent, like, okay, well, some of them didn't buy the product from that manufacturer, wouldn't have bought the product from that manufacturer, but they would have bought the same kind of product, something very similar from some other manufacturer. And then the rest is what is maybe broken into, wouldn't have bought the product at all. But in yellow, those are the people who well, but they're happy with it. We knew their true, authentic self. We'd say, okay, this was good. And then the red is what some refer to as created demand in a sort of scary sense, that these are people who, if we knew their true self, they'd regret buying this. And that's the portion that, kind of like advertising is bad, where it's clearly bad. And so advertising is valuable because that's not green is the lift. That's the extra purchases that happen because they advertise. But green is a lot of the pie. It's a lot of the pie, right? Okay, so if we think that something similar is happening but again, here's where I feel a little uncomfortable, but I'm guessing it's somewhat similar, that, more than half of the people who, share or are pitched some racist or just wrong-headed in some way media story probably actually already hold those exact same beliefs. And then the blue portion, might not hold those precise beliefs, but they hold something so similar that we kind of categorize them together. And then the yellow portion, maybe they were genuinely influenced and they are glad that their mind has been changed, and then the red portion is what we need to worry about. And so we can fight about where the breakdown is, but if we understand that it's something like this, then that forces us to be honest about whether Facebook even has much to explain in terms of causing changes in people's beliefs. So that's factual cause. And then even if we agree that a sizable chunk of the pie should be red, so it should be the bad form of influence that we don't want in political spheres, the next question is whether we should, the proximate cause question, well, should we hold Facebook responsible for basically the dissemination and adoption of bad ideas? I remind all my tour students that just because there might be some actor or a few actors that are clearly more responsible for something bad happening, it doesn't mean that we need to relinquish any responsibility from someone who was upstream that could have anticipated this. So just because the purveyors of bad content are definitely responsible for something bad happening, it doesn't mean that we need to let Facebook off the hook. So, but should Facebook be on the hook in this sense? Sorry. So I think here this gives us a sense of why the debate has latched onto the concept of manipulation, because if there's manipulation involved, there's a bad actor that in theory Facebook could have anticipated and maybe had enough information to anticipate, and therefore we should do something. Facebook should have done X, should have done something. And so what does manipulation mean? That requires us to actually go ahead and dive into what this, what we're limited to talking about. Well, Bankler's book uses directly influencing someone's beliefs, attitudes, or preferences in ways that fall short of what an empathic observer would deem normatively appropriate in context. Oh no, so it's like the last part that I think we're gonna have a hard time agreeing on. They also kind of more usefully, I think, say, well, what we really mean here is disinformation, so intentionally misleading someone, propaganda and commercial bullshit. And there I think, okay, maybe we all do kind of have a sense that maybe we could all agree on what that is, or we'd all kind of roughly identify the same things. So, okay, I'm willing to work with that definition. And then if there is such a definition, then maybe there would be some kind of policy that we should ask and expect Facebook to do to minimize it. But I am not sure that this stuff that everyone would clearly call disinformation, propaganda, or commercial bullshit is really going to do much anyways to solve what I think are the most politically pressing problems in democracy and polarization right now, or so they might be small potatoes. And the reason I say that, and here I'm really starting to wander into territory that I know there's some empirical support for, but it's not my area of competence. So so come find me if I'm losing you. But here, where I start to disagree with Benkler and his co-authors is that they're looking at a graph like this to show that some media are being less responsible than others, just sort of by virtue of their being very, very isolated. But I think there's a problem that all media, across the spectrum has been engaging in part because they're pushed by the market to do it, and in part because I think it's just how we have come to expect news to operate, which is that they focus obsessively on threats. I mean, I think the news usually is expected even to give us a sense of what is negative and is happening. And a lot of threats tend to push us into kind of tribal corners where we are starting to think in zero sum, right? So, happy news doesn't necessarily sell. So to give some examples, these are all things where, at least for most of them, there are real problems. So I don't mean to suggest that this is, misinformation in the sense that it's all factually inaccurate, but rather what can be misleading about the amount of attention that is paid to each of these problems, which we see a lot across the spectrum and in all the news, is that they may overrepresent how much this actually affects our life and lead to drowning out the ways in which life may be less dire or even improving. Sometimes that happens, I think. And then the last, which I saved for the end, is technology, because the other four, I mean, there might be more that I could put on this list, but the other four, you can kind of like code them ideologically. But technology is always in the barrel for everyone, right? No one, it's very easy. It's a mainstay of resentment and fear on both sides of the aisle. So where does that lead us? If I'm right that much of what is ailing us right now is this overwhelming sense of threat that is causing us to fall into the extremes, It's not clear we want to solve that, right? It's not clear that we would want to force Facebook to do something specific to try to undo those. Or another way of putting that is, just as there may be multiple actors legally responsible for some sort of problem, there are also some problems where the best course is saying that, at least for now, nobody is legally responsible. So I don't know for sure that that's where we are, but that's the best I can do with the information that I have right now. So thank you.
Thank you. When Jane mentioned to me on the side that a lot of the issues that were posed as we were back and forth with each other and prepping for the panel were ones that she hadn't really completely made up her mind on what exactly is the right answer, I said, you're in good company. So Alex Rosenblatt is a technology ethnographer at the Data and Society Research Institute and the author of Uberland, How Algorithms Are Rewriting the Rules of Work. She had an op-ed in the New York Times last fall, I think it was, on fascinating research that she did on the ride-hailing business. So Alex.
Thank you so much. I just want to make a quick comment on our last amazingly interesting presentation. Thank you so much for that. I don't think political persuasion is the only dynamic at play. I think what we're also looking at is political representation in surveillance capitalism. When you hyper-segment by their behavioral and other traits and show them products or services in their own image, you are creating a resonant message about representation. And it's interesting to think about how much Silicon Valley platform companies do to create virtue signaling, marginalized identity politics. Uber will transport you to the gay pride parade and show you on your screen, a little sedan with rainbow colors. Airbnb will advertise interracial couples visiting new cities and having tourist experiences. What they're signaling is we're here to create normative space, safety in a lot of these interactions. And so I just wanted to flag that as a cultural parallel to advertising and hyper-targeting, because I think it's one of those under the cover dynamics that isn't at play now, but people will be invested in later. So now moving completely away from that, I've been studying Uber through the lens of its drivers for about 4 years. I started in 2014 when Uber was still the darling of the media and business and technology beat. And at the time, they offered a lot of really interesting benefits that they had proposed. One of them was that they would enforce a policy of blind passenger acceptance. That means that the driver who's receiving a dispatch from an algorithmic dispatcher doesn't know where you're going. In theory, this can resolve a long-standing issue about curbside discrimination. If you're a person of color, especially if you're a black man, hailing a taxi on the side of the road can be a real problem. They might pass you by and go pick up the nearest white passenger. And so Uber was twinning, a couple of different messages when it came to town. It was saying, hey, the regular rules and laws don't apply to us. We're not a transportation company. We're a technology company. That also means, by the way, that the Americans with Disabilities Act might not apply, because that applies to transportation companies that have to provide accessible services. But they were saying, well, we are a technology company, and we care a lot about using technology to resolve and create resolve social problems in society and to create a lot of benefits, because you always have to have morally persuasive messaging around disruption. And that's been pretty fascinating to see, because as the years went by, what I was observing when I rode around in hundreds of cars with drivers across more than 25 cities in the US and Canada was that Uber's messaging often didn't align with how drivers were experiencing their work. And so this initial policy where you have blind passenger acceptance was one of many management rules that determined how you had to behave on the job with limited information and significant power asymmetries between yourself and the platform. And what I was uncovering through years of research was that, of course, Uber drivers are narrated and marketed as entrepreneurs who can be their own boss. But of course, they have a boss. It's just an algorithmic one, and it's hard to see. And when I say algorithms, I really just mean there's rules encoded in software. And there are qualitative shifts that are happening in the workplace as a result of automated workflows and decision making. But essentially, they have rules that they have to follow or they risk being deactivated, a technology word that means being suspended or fired. But using a technology word is important because it keeps these relationships in the realm of technology culture, which has experienced a great deal of exceptionalism to many of the rules and norms that would apply to industry competitors. So as I started looking at the algorithmic boss and all the different ways that drivers experienced how, well, Uber leveraged a significant amount of control over how drivers had to behave at work, I started thinking about this paradox. And I was really hoping that the contingent of antitrust lawyers here today would help me with it. Because either Uber drivers are independent contractors, which is how Uber classifies them as it narrates them as entrepreneurs, or, and this has come to light, through, or they're misclassified. So the kinds of control an algorithmic boss can leverage over how you behave at work might suggest that you should be an employee. But let's take for granted for a moment that Uber drivers might be independent contractors. Uber sets the rates for hundreds of thousands of independent contractors across the country. So I was hoping to find out whether they were a price-fixing conspiracy or whether drivers are misclassified. The antitrust lawyers I've spoken to so far have told me it's much more complicated, which is great for the legal profession. But I wanted to talk about how Uber's model is actually disrupting or upending some of our conceptual frameworks. There's the simple one where a lot of labor law doesn't apply if you're an independent contractor. It doesn't offer a lot of protections. But there's also, we have certain rules that came into place to try and create fairness in society that are upended by that too. Let's take the rating system, for example. If you've ever taken an Uber or a Lyft or something like it, you'll notice that at the end of each trip, you're prompted to rate the driver on a scale of 1 to 5 stars. And Uber drivers, by the way, receive notices that say, 5-star drivers behave in the following long listicle of ways. You don't have to comply with these rules, but actually, if your rating falls below a certain threshold that Uber establishes, like 4.6 out of 5 stars, you get fired. You get deactivated. And that's very interesting because as independent contractors, drivers aren't protected largely by anti-discrimination laws at work. And yet, we had a bunch of rulings a couple of decades ago where, let's say a department store argued that they only hired white female clerks because that's what their customers preferred. And courts rejected the argument that you could discriminate on behalf of your customers. Now the rating system ends up masking the kinds of biases that passengers themselves might hold that filter into the employment and termination decisions that Uber as a platform can make. And so the types of efficiencies that Uber has introduced to scale this service through rating systems as a stand-in for quality control over drivers and algorithms that dispatch hundreds of thousands of drivers to pick everybody up, also fall short in a couple of other ways that are harder to unpack. There are also a lot of material benefits to automating workflows to think about too. One great thing about Uber for drivers is that once they log in, they pretty much get a job. They can get to work right away. Uber takes care of a lot of the supply chain. They just dispatch you a rider and they set the rates and away you go. That's a material benefit that a lot of other gig economy workers actually don't have because they might be care or cleaning workers on platforms that function a lot more like marketplaces. So on Care.com, which has over 10 million active job seekers, the platform doesn't do that coordination work. They have to, someone who wants to try and find a job as a care worker has to message back and forth with a potential family or employer to try and figure out how they're going to arrange the terms of their work. And that's a lot of communications work. Uber is just like, hey, we're just going to dispatch you this ride and this trip and this job, and you can get to work right away. So there's definitely a benefit to shifting automation in workflows, but there's also some soft losses. There's social debt to automation. There's often a lot of discussions around the technical debt that machine learning systems and automation and AI systems acquire, but I think a lot about the social debt that these systems also engender. And I'm going to give you a brief example. So within Uber's model, when drivers experience a problem at work, like a passenger sexually harasses them or other harasses them, they don't have a human supervisor to turn to. Their boss is algorithmic. They've learned the rules through hundreds and then thousands of communications from Uber, through in-app notifications, through text messages, through emails. And when they have a problem, they have to write to an often remote customer service agent that could be located in the Philippines. It's like the email equivalent of a call center, although in the last year, Uber has started introducing some other options as well. But for the bulk of my research, that was kind of the deal. So you get sexually harassed by a passenger, you write in, you get a form letter back saying, like, we're so sorry. But that form letter might also say, hey, we won't match you with this passenger again. And the driver's sitting there going, you know, I don't want another driver to experience this too. Why can't you deplatform this passenger? Or why can't you use my report as a mechanism to try and investigate that passenger, to try and create safety? And so there's a way in which this disaggregated, very automated workflow leaves people feeling like they're stuck on the side of the road, like they've been excluded from participation in a common mission at work. And so that's just something to keep in mind when we're talking about using the Uber model to scale work in a lot of different industries. It is, of course, it's become a symbol and almost a framing device for how we discuss the impact of technology on work, and that stems in a billion different directions. So I thought I was studying Uber drivers, right? It turns out I was studying a ton of different conceptual frameworks that were coming into play as Uber's maneuvers those maneuvers were regulatory arbitrage, brought me into a lot of different areas. So one of them would be, oh, is this price fixing? Yep. Oh, is this misclassification? But another one is, oh, if you work for an app, are you a consumer or are you a worker? So when a lot of Uber drivers sued Uber over potentially misclassifying them, Uber's lawyers said, well, drivers are just consumers of our technology, just like passengers. Which seems incredulous on the face of it, right? But I started to think about it a lot more because I noticed that a lot of Uber's practices that employ drivers and manage drivers also came from consumer-facing Silicon Valley companies like Facebook. So drivers have an algorithmic boss, and it manipulates a lot of the choices they have available to them. But often, algorithms in technology culture have been narrated as neutral, sort of benevolent, objective, mathematical facilitators of connections of various kinds that are, invisible. Facebook doesn't show you an editor to determine your news feed. Algorithms do that. And Uber was not only importing the rhetoric of neutrality, it was also importing a variety of experimental practices that we've seen on consumer-facing platforms. To give you a brief example, at one point, Facebook ran an emotional contagion study where they would alter the news feed of some users to show them sadder status updates to see if that sort of spread, and alter the news feeds of others to show them happier updates to see if that would spread. And when news of that was reported, people were outraged. Why were they outraged? Well, they don't want to be experimented on, especially when it comes to their emotional well-being. But also, it directly contradicted the myth-making we've done around algorithms and how they're neutral rather than forces of manipulation, how they're more than simply connective tissue in a large system of services. And I thought about that so much when Uber implemented something called upfront pricing. And I think, well, a couple of years ago. So this is how it went. Uber drivers have long had contracts and an understanding that they would be paid, a certain amount per mile and per minute, and they would remit back to Uber a commission based on what the passenger paid. And the passenger was paying the same rates as the driver was receiving. And so that commission would be, let's say, 25%. When you look at the fees, it's really more like 30% or higher. And that's how it went. But at a certain point, drivers started noticing something fishy was happening. Passengers were sometimes being charged higher or even lower fares than the market rates would determine. So a passenger pays $90 and a driver gets $30. Suddenly, Uber's taking a much larger commission, or even in some cases, a lower commission. That's very interesting because it falls into this understanding of, well, of course, you're just our users and we can experiment on you quite freely. But of course, when you look at these practices in the context of a workplace, somebody's livelihood is on the line. It's a lot clearer and a lot more legible as a harm that we can sort of wrap our heads around. similar kinds of discomfort in a consumer space often end up in this sort of muddy uneasiness that, well, we're consumers of a free service. How much can we really complain? You know, but when it comes to work, there's a greater sanctity already built in, which is why it became a pretty useful use case for examining how Silicon Valley practices can be manipulative, how we can all be managed by algorithms in ways that are hard to see, and it's hard to assess when you're being led in the direction that is in your personal interest and where it's not. Another reason I started to think about Uber drivers and how they might be considered consumers of technology services is because the FTC intervened at one point. So Uber recruited drivers with exaggerated earnings claims, like $90,000 a year. I think this messaging was somewhat limited to the United States because when I went to Canada and talked about this, they were like, what? What kind of incredulous fact is that? But in the US, that was a widely disseminated fact, that drivers could make $90,000 a year. And they made those claims around 2014, and the Federal Trade Commission intervened and said, well, no, that's deceptive, and they sued Uber. And as they sued Uber, they said drivers are entrepreneurial consumers. And I remember looking at that language going, wow, they've called them entrepreneurial consumers. What is this shift that is happening in all these different corners, whether it's in a labor misclassification lawsuit or in a consumer protection context? And that's not the only place where we're starting to see a coalition between consumer interests and worker interests. We can see it bubbling up around issues of data collection and workplace surveillance, where workers might want some of the same protections we're building for consumers when it comes to privacy or the limits on data collection and its use. So there's an interesting way in which there's cultural conclusions surrounding these dynamics of disruption and grappling with how you implement accountability for technology platforms. And that's why I wound up looking at all these different areas when I thought I was just going to be riding around in cars with strange men, sometimes women. I would also highlight that although this workforce is often narrated as very disaggregated, very like a relationship between like one driver and a platform, there's also ways in which drivers have used the other platforms we've discussed today, like Facebook, to forge a workplace culture. So not only did I ride around in hundreds of cars, I spent nearly every day for 4 years in Facebook groups that were dedicated to driver issues, in driver forums elsewhere, in dedicated websites. Drivers often have WhatsApp groups as well, and and different sort of linguistic communities of that. And they've forged a workplace culture that's premised entirely on information seeking, because the pay structures for a lot of these gig economy companies become really confusing. And the experimental culture we're familiar with from Silicon Valley has merged into the workplace in ways that make it hard to figure out what's going on. A really obvious example of that came to light this week around Instacart and tipping. If you've seen the reports, what happened is Instacart implemented a policy where shoppers, which is what they call them, are guaranteed, let's say, $10 per job that they do, but Instacart will also use the amount a customer tips as a substitute for those wages, which is, of course, deceptive towards consumers. No one's like, let me tip you so your employer doesn't have to pay you. Like, I'd just love to do that, you know. But it's something that Instacart shoppers have been talking about and crowdsourcing in many of the same ways that drivers had to figure out that upfront pricing had been implemented before it was a formal or explicit policy, because they were crowdsourcing in these forums and saying, look at my pay stub, did this happen to you? Did this happen to you? And of course, when these are reported on, the companies will often use the exculpatory language of technology to describe something like wage theft as a bug, or price discrimination as an innovation in artificial intelligence. And so I will end my talk here by putting an asterisk on the rhetoric of technology and how much of that is theatrical. There's ways in which, when we're talking about ways to regulate platforms, there are significant new things to grapple with. There's machine learning, and it relies on having 1 billion well-labeled of examples of any given item so that you can create efficiencies there. But there's other instances where when you're talking about algorithmic transparency or platform accountability, you're talking about wage theft or tip theft, or not, like it's really basic, you're talking about consumer deception, and so I would put the asterisk on, don't be swayed by the technology theater that creates and builds on our culture of technology exceptionalism. A lot of the time when you get down to it, it's a very simple transaction, but it's covered in lots of linguistic difference.
So forget theater, carnival barkers. I mean, like, no, it's just infuriating, sorry. That was a great talk.
So before we go to the response, the one observation I had on that was one of the wonderful things about coming here is the interdisciplinary conversation. So we know we have engineers, we know we have economists, we know we have too many lawyers, but to have an ethnographer come in and give that additional perspective, I think enriches the conversation. So thank you very much.
Thank you.
So to continue the dinner party metaphor for dinner party download, Len Callie is Senior Vice President for Global Public Policy for AT&T and has watched this space and many spaces for a number of years, always with a very sound perspective. So turn it over to Len.
Well, thanks, Rebecca. And let me start by commending all three panelists. This was fascinating presentations, very thoughtful, so really appreciate it. I'm going to start from the premise that I think consumers do deserve certain baseline protections on the internet. Policymakers certainly can't solve every problem, nor should they try, but they can do more than they've been willing to do. Casey Claffey had talked earlier about the early history of the internet, and one of the things I wanted to note was during the early days, US government policy was really to protect and nurture the growth of the information services industry. The government did this by shielding information service providers from certain obligations that apply to other companies, from building moats around them to protect them from competition, particularly from the telephone companies, which were monopolies at the time early on, and there was concern about them being crushed. But most importantly, perhaps, they did it by exercising significant restraint and regulation. So these nascent companies could grow up. And as Commissioner Chopra said earlier, these platforms are no longer small and scrappy startups. So we've come to the reckoning, and I loved what Professor Limerick put it earlier. You know, the reckoning followed the early excitement. Given the dominance of certain of these platforms, their size, and the recently recognized dark side that has accompanied their growth, I mean, people really are asking, is it time for policymaking to catch up with market reality? So some of the questions are not new. They may only call for applying long-standing, robust legal frameworks to novel circumstances and new business models. The questions will be challenging, but I think we have these time-tested frameworks that can be applied. Aspects of privacy, copyright, and competition law probably fall into that category. Other questions may call for fundamentally new frameworks. Some of the things you were talking about, Alex, really are interesting and need a lot of thought and a lot of understanding to understand how we address them. But in any case, we as a society should be laying down guardrails so we don't end up in places we don't want to be. Jay and I thought, Professor Baumgartner, I thought you did a great job of highlighting some of the challenges of regulating, particularly in the privacy arena. In some of the materials you shared before the conference, you also highlighted that there were consumer interest on both sides of this privacy conversation. There are some consumer benefits here. One of the things you did that I thought was fascinating, I hadn't seen it before, was you referenced the study of home loans in San Francisco. And some of the counties in the San Francisco Bay Area set the privacy default in a way that there's higher privacy protection. Others set it lower. And I guess after you think about it, it's not surprising, but what you find is where the privacy protections are higher and therefore information flow there's more friction, the loan rates are higher and the default rates are higher. So clearly there are some consumer benefits. And all it says, that's not to say we shouldn't be setting the default high, but it is saying there's a balance here that should be struck. So there's plenty of reason for caution. There are First Amendment issues at play. There are consumer benefits that we've seen across the internet at play. But I was going to raise some questions that things we should think about. For instance, should we, as a policy matter, or as a platform responsibility matter, think more about how do we improve transparency? There was a great panel right before this one talking about transparency. How do you give consumers knowledge of how their information is being used and control over that? Is there some information we want to restrict altogether, or at least restrict in its use in certain ways? We talked about discrimination in the last panel. How about telling users about the source of information, at least political information? Or why are they seeing some information being presented to them? Should platforms host false information, harassing information, pirated or unlawful information? I look at the chilling examples Professor Citron proposes. Should platforms be allowed to engage in knowing behavior that she discussed and enjoy blanket immunity? Should they be free to hold themselves out as neutral platforms, but in fact, in subtle or not so subtle ways, discriminate in the ways information are provided to consumers? Do intermediary liability protections continue to make sense for those platforms that make money based on models that drive engagement through curation of content? Are the laws that we developed to help facilitate the growth of these platforms still the right ones for an online ecosystem that is not only developed, but it really is omnipresent today and has such a huge impact on all our lives and our society? You know, as Professor Citron pointed out, Section 230 was established to encourage moderation, not discourage it. But before Cambridge Analytica and the Russian interference in the elections, there wasn't much moderation going on beyond some limits around inappropriate images. So the questions, as I mentioned, become more fascinating and complex when we start thinking about AI and some of the things Alex talked about. But I think what I'll do is I'll close with 2 points. First, I've laid out a list of questions. It may sound like a call for heavy regulation. It's not. The question really is, how do we preserve social values on the internet? It doesn't mean we necessarily need heavy-handed regulation or a new regulatory agency in Washington, but we do need some thoughtful approaches. We can and should start, I believe, with Congress establishing some baseline protections for consumers, including enhanced transparency, privacy, and open internet obligations that apply across all internet companies. Second, I'd urge, let's not let the perfect be the enemy of the good. We do not have all the answers today, and we're not going to have all the answers for a very long time, if ever. We have to act with caution. That council's acting with caution. The balance I talked about earlier says we have to act with caution, but we should begin taking steps in the direction of greater responsibility.
Thank you, Len. And Judge Williams, Judge Williams is on the bench of the DC Circuit, as you all know, and brings to these conversations a wonderful perspective that comes from having practiced law taught here, then judged, as well as, and to echo Phil's thanks and recognition to Judge Williams for coming to this event for every year for so many years. And also, I think the broader perspective that comes from looking across a whole range of issues, industries, world questions that comes from sitting on the bench. So I welcome your comments on this. Thank you.
Thank you. And I should say I thank Silicon Flatirons for having me so often. And I've learned a huge amount in the course of it. I want to focus on a theme of Professor Rambauer's, which in a way is encapsulated in that pie chart with the pale green that was a little bit over the majority. Now, that was a slightly understated version of the phrase you had in your paper, the paper you directed our attention to, which, talking about fake facts and so forth, talked about the tendency to believe fake news was highly correlated with the content already matching the reader's political beliefs and with the reader having an ideologically segregated social circle. And it's that and the disease that represents that I really want to focus on. You, putting together your paper and your presentation, alluded to the election effect, the possible election effect, and to divisiveness. And as you were speaking, I was trying to think, those are not what I'm primarily concerned with. Divisiveness seems to me entirely natural in a highly pluralistic country of 300 million people. There are going to be a lot of different views, and they're going to vary radically. The question is, to me, is whether those views get expressed in a way, I guess I'll put it in the most key way, which shows respect for the possibility that the other side might be right, at least in part. and you know, you can be devices as all get out and still not be contemptuous of the people expressing different views. So, but I agree that you're, and I'll go a little farther with your speculation, that we're talking about information enjoyed by the ideological silos where it lands. So why is that so much a feature of our current life? And I mean, one simple way of putting it is that we have, through the social media, we have editors with an incentive to whoop up the enthusiasm of their readers. And the sort of blunt way of saying that is to serve them red meat. And that seems to me very dangerous. It is not consistent with a culture of mutual respect. I should say that without naming names, I think it is clear that this tendency has spread to other media, and I'm not sure why. At least one factor would be a sense of competition with the social media, and I want now to urge the creation of a new discipline, the epidemiology of contempt. I would like to see that elaborately explored. Now, I want to contrast the current situation with the bygone era of 3 TV networks, preserved in that number by the FCC, and with a result that was criticized. These stations were criticized, I think justly, for a lack of diversity of opinion. They were all trying to occupy the middle position, that's where the profits were. And just to give you a little economic background, that is an application of Hotelling's law, which is encapsulated on Wikipedia with the following sentence. It's an observation in economics that in many markets, we'll see how it's different in the social media, it is rational for producers to make their products as similar as possible. And so there's a geographical allocation of that, the form of that involving geographical allocation, which is why shoe stores tend to cluster all together on the mall, and why the theology of Methodists, Presbyterians, Episcopalians, and so forth does not really vary all that much. They're aimed at the middle. So what changed after the grand era of the 3 networks? Obviously, ease of entry into the field. So you have the market of blogging and site creating meant entrepreneurs have an incentive to get niches, not trivial niches, big enough niches so that there might be some payoff in advertising opportunities and so forth, or being picked up in bigger media, but obviously much, much smaller than the 1/3 of the TV viewing public, which was sort of the target of each. Of course, they wanted slightly more than 1/3, but anyway, that was the target of the TV networks. So you have the creation of a market where red meat is a really winning commodity, and that seems to me not a good thing. It's a sad case, if my analysis is right, where increased competition leads to an inferior social equilibrium. So what might be done about it? I'm not even going to talk about possible legislative changes and that sort of thing. The optimist in me wants to suggest that there might be changes in behavior on the part of producers and consumers. Producers might try to compete by offering a balanced diet, and I want to emphasize that when I talk about a balanced diet, I don't mean a left-wing scream and then a right-wing scream. I mean someone who was able to put together a reasoned expression of competing views. And actually, I mean, I know of one such producer, and that's the Flip Side. I don't know if any of you follow it, and I understand that others may be on the way. Now, will there be a market for this? Well, it depends upon the taste of consumers and the ever-relentless optimist in me thinks there might be. Many parents here have had the pleasure of reading to their children Bread and Jam for Frances. Frances wanted to be able to go to school with a lunchbox with a jam sandwich. And her parents decided to indulge that taste. And lo and behold, it only took about 3 days for Frances to get really tired of that diet. It seems to take longer for people to get tired of the diet of red meat, but I'm optimistic in thinking that at least at the margin that may happen. Now, wanted to broaden it slightly by taking an observation made by Megan McArdle in her column in the Post, drawing an analogy to the invention in the 15th century of the printing press. And she characterizes the effect, her words really are wonderful here because it's such a marvelous understatement. She characterized the effect as being a reorientation of European politics toward religion in a way that was previously unimaginable. Now that seems to me a very kind and gentle way of referring to the launch of 150 years of savage warfare. That certainly, it's a new view, previously unimaginable. Of course, because it broke a monopoly. It broke a monopoly, and the people were able to express themselves in very vehement ways, and probably the same reward to the offering of red meat was available there. Now, that ended with essentially the Peace of Westphalia. That's what sort of the end of the 150, not quite 150 years, a little under 150 years of savage warfare. And it ended, incidentally, with sort of the adoption of a view that you don't interfere in a country just because they have different internal politics, which for the most part meant different internal religion, and built into that was a norm that the ruler of the country decides the religion of the people. That's not very good on religious freedom, but it's a hell of a lot better than people killing each other endlessly. So it was in fact a step towards religious freedom. It was religious freedom ruler by ruler rather than by believer by believer. So it was progress. Now, 150 years of bloodshed will seem a high price, and I obviously agree with that. I think that a movement towards respectful disagreement will be quicker and less bloody. Why do I believe that? I have no good grounds for it. I am a cockeyed optimist.
I love
So that's it.
Thank you for appealing to our better angels. I appreciate that. I appreciate that. I'm going to break from the format just a little bit before we go into questions that I have. I'd like to call on students for their questions. And you're going to have to like show me your student ID or something because I don't know who's your student. Anybody? Bill, can you help me pick somebody?
There's a couple down in front.
Oh my God, poor Anna. Yeah. Right, Sarah. Right.
Great. Thank you.
Again, I'm Sarah Rippey. I'm a 2L. So my question is for you, Danielle. You were talking about Section 230 and trying to alter that to make it more applicable. So would you impose liability only on the sites that encouraged and facilitated the abusive behavior, or would you impose an affirmative obligation to moderate?
Okay, so great question. We could approach it in several ways, some more modest, right? And others, I think, to create practices of responsibility so that the first suggestion, right, the very narrowly taking away the immunity from the bad actor, right? The encouraging and facilitating known and clear illegality is one way, I think, to buffer some of profound concerns about censorship creep. Just to add to this conversation, in the midst of all this essentially regulatory vacuum that that we see not only Uber and Amazon for like poisonous products saying they enjoy Section 230 immunity, which is just frankly painful, right? It's just an overblown understanding of what a speaker and publisher liability is, right? So we're in this pervasive regulatory vacuum, and at the same time, Europe has been for the past 2 years insisting that the 5 dominant platforms remove hate speech with a very vague understanding of what hate speech means, pursuant to a memo of understanding within 24 hours. And now Germany's passed a law, so we're seeing the winds of, we always think of laws moving as like a pendulum, right? Where law, and this is the story of tort law, you move from no liability, right, overprotective of business, to overprotective of consumers, so strict liability, and we want to get somewhere in the middle. We have remained in this regulatory vacuum for a long time, and now Europe is bringing in that sort of the story of overprotection. And I think what ultimately my intuition, to answer your question, like where should we land, what's the best place for us to land, is to condition the immunity on, so not as narrow as just facilitating, encouraging illegal uses, but to pair the liability or condition, the immunity with reasonable practices in the face of either to prevent or to address known illegality. And so that moves us still away from the world of misinformation. We can't punish misinformation, right? So this is still quite narrow within our commitment to the First Amendment, right, what we can do. And players like Facebook and Twitter, they engage in reasonable practices, right? They think it's bad, now they think, God bless, it's bad for business, stalking, harassment, threats, and non-consensual pornography, right? And it's true that I always get this criticism, and I acknowledge it, that the new entrants will have a much tougher time, right, moderating content than do the behemoths, right, like the Facebooks and the Twitter and Google, et cetera, Microsoft. But you know what? We shouldn't have businesses that, you often say, like, everyone should sell products that are going to poison people. No, right? We have regulatory structures that we've imposed, much as the way we think of the car industry, right? They went from no liability to the 70s, which, God bless, now it's much safer, right? So I think the idea that we remain in this regulatory vacuum, I don't want us to move too far. I don't want to be the European, and I've written about censorship creep and a great worry that I have about that pressure that Europeans are putting on the dominant platforms. And at the same time, it has to be understood in a context of regulatory is a void. Forget the arbitrage. Like it is a void of that, of regulation. That getting somewhere in the middle is where I think I'm most comfortable.
Thank you.
Thank you for the question. I'm gonna throw one out to Jane and then take another one from the audience. I'm assuming he's not a student. You, in your presentation and in the writings you've done, I think you rightfully call people to task to be more rigorous and demanding in terms of what we're claiming for the impact of a lot of the junk that went on up to the election. Everybody, was reeling from that and may have overstated what the impact was. And so cautioning that we move to regulation. Taking it out of the realm of political speech, though, we have seen many claims, discussions, and I think most people, but you may disagree with that, think that there has been a fairly clear link between hate speech and particularly religious divisive speech that has led to violence in Myanmar, in Burma, threatened violence in Houston here, and so what thoughts do you have about how we, and a lot of the experts on both sides of the political aisle in Washington have worried about the impact of a lot of that speech on security in many different ways. How do we, I'm not suggesting you're saying do nothing, but how do we decide where to calibrate that type 1 versus type 2 error, which we're always going to have, right? How do we think about what factors to take into account as we try to calibrate that to decide between overaction and underaction?
Yeah, so I kind of knew that this question was coming, and I had, out of concern that my mind went blank when you asked over email, I reread about the Myanmar example and India example and whatnot, And so the reason I bring that up is that the New York Times article that broke the story about I think it was the Myanmar story, was titled "When Nations Are a Tinderbox and Facebook is a Match." And that kind of captures a lot of what I was talking about in my talk anyways, that Facebook can't be expected to keep tinderboxes from catching fire. Or, not, you know, we should have modest expectations about whether we can keep tinderboxes from catching fire. Facebook also, I think the other thing we should keep in mind is that Facebook has, so I think many of the scandals that have risen over the last few years have been useful in disciplining Facebook using sort of public relations pressure, and Facebook has seems to have more interest, maybe it will be enduring, maybe it won't, to be sort of a more responsible citizen and to look like it's on the right and moral side of history. And by the way, I don't mean to sound like I'm shilling for Facebook. I don't even really like Facebook, but in terms of whether we should, of whether there's a harm that we are in a critical moment to address through public policy, I'm still not sure. And even with the examples of violence, when it comes to video games, I know that this is pretty well documented, and my guess is it's the same with social media, that despite the fact that it looks real ugly in the video games and real ugly online, this is controversial, but in my opinion, there's the bulk of the evidence suggests that actually people do, you know, they kind of sit on their butts and do less, and they're sort of overall less violent when they have these kind of, you know, fun alternative worlds to dive into. So that, I know that's controversial, and maybe other people even on this panel don't agree, but that's all just to say that I'm not, you know, I would, even in that context, I'm reluctant to say that this is our moment to do something government-wise, yeah.
Any reactions to that question or any other questions?
I have a question, so I'll hold it until reactions to that if you want.
Any reactions? We good? Okay.
Okay. This is a question to the panel, but it's prompted by something that Professor Citrin had to say about Omegle, the site that connects predators to children. When Backpage was still operating in the U.S., it was credited with between 70 and 80% of the child prostitution. And but the founders of Backpage were very concerned about that. They worked a lot with law enforcement, and in fact, in 2011, the FBI gave the president of Backpage an award for his work on fighting child prostitution. And in fact, the Backpage had established a unit inside of Backpage that would often, within an hour, be able to turn around information requested by law enforcement, and they freely provided people available to them, freely provided Backpage people to law enforcement for purposes of testifying and so forth. And this was, of course, prompted by the fact that Backpage was under U.S. jurisdiction. Once Backpage was closed down, OneBackpage.com opened up outside of U.S. jurisdiction, and of course all of that cooperation ceased, and there have been 0 children rescued from there. So my question is, when you're talking about reforming Section 230, it seems like from a results-oriented perspective aimed at rescuing the children, presumably what you're advocating is changes to Section 230 to make sure that the U.S. becomes the preferred venue in the U.S. for child prostitution and things like that, so that those sites are under U.S. jurisdiction and we can get those good results as opposed to the bad results we see when they've moved outside of U.S. jurisdiction.
So I have to say that I think you've got, at least as to Backpage, the facts like turned upside down. Backpage, it has been so shown that you might be talking about Craigslist, but Backpage, the owners, were in league and working with and designing their site to ensure that child sexploitation, people trafficking children, were not caught, and also creating the ads for quite a bit of money, with the sex traffickers. They have been arrested by the Department of Justice. So the First Circuit, and part of what I think made me write some of my more recent work on Section 230, is that it was very clear from the record in a First Circuit case that Backpage's owners were designing their site to ensure that sex traffickers of children were not going to get, it was masking their identity. And there was, in the record evidence, they were doing that. And the court says, the First Circuit, finds Backpage not responsible for their changes in design of the site because who is trafficking? The users of the site. And they say, but if we find out that they're co-creating the ads, that would be a different story. And the coda to that story is that DOJ throws them in jail. They're literally not free right now because they conspired with sex traffickers. So you might be talking about Craigslist. I'm happy to talk offline with you about the Backpage case, but the reason why we have FOSTA and SESTA, which is a misstep in my view, in the way it's drafted, is because of Backpage. And it turns out that Backpage we dealt with criminal law, right? So your question, though, underlying it is a good one, which is if we create regimes of responsibility, whether it's reasonable practices or encouraging, discouraging facilitation of crime, that we're going to then push outside the United States and outside of our jurisdiction the bad actors, right? So I take that's a good question. It's really true, right? A lot of revenge porn sites operate in Russia. They're actually nicer in Russia. They take stuff down when victims go to them, believe it or not. That is true. We're going to see illegality outside of our jurisdiction, but in what we can control, in our universe of what we can control, and we also know that if you're outside of our jurisdiction, if you engage in sex trafficking of children, we can catch you. Certainly law enforcement has much greater resources and depending on an extradition treaty can get the defendants. So I'm not entirely sure that they're going to be outside of the reach of the US law. It just makes it more difficult and challenging.
So I got a sign that we're done. But wait. I want to ask you guys a question, and this is an unfair question because I'm lumping everything together that are the harms that we've talked about, when my own view is our conversations do that too much and it does a disservice to trying to figure out what the answer is, that we need to parse them out more separately. But I want to ask a question, hands up, hands down. For all the things that we've been talking about today, whether it's data misuse, whether it's misinformation, whether it's Section 230 restricting that to try to create some better incentives, who here thinks, raise your hand if you think that it's premature to do anything and we should just sit back for another, I'm making this up, but 3 to 5 years and see how this all goes before we start regulating? Raise your hand. Okay. Who here thinks that we may not be at the algorithm of terror that we talked about this morning, but that we're creeping there, and it's time to have serious discussions about I'm not talking about transparency for the moment, but a regulatory response to some of these issues, sort of a la what Mark Warner was talking about. Raise your hand.
Is that a third choice, or is that?
That's it.
Oh.
Thank you. And thanks to the panel.